that remains in Holland definitely a difficult action. But once there is a willingness to settle, this Collective Settlement of Mass Claims Act offers an excellent opportunity to assist the non-US persons. You see the international mass claims, legal proceedings after Morrison. The non-US persons might not find the redress they wished, and that's where the collective action in the Netherlands offers an opportunity on the basis of this act. Recent Act 2005 was not enacted after Morrison. It was not a clever commercial move to attract some of the business. Toronto indeed is much more attractive for, and in true competition. Just after Morrison, I was invited to participate in a webinar of the American Bar Association, and the other participants were class action lawyers, litigators, deeply disappointed, very disappointed by Morrison, very afraid that the business moved out of their hands. So I could bring them the good news. I said, listen, we still need you. We need you to bring that party into submission. And once there is a willingness to settle, we have a fantastic possibility to do so. It's enacted, part of the Dutch Civil Code, initially inspired by personal injury case. DES, our firm represented the insurers, DES was a medicine, and that created a lot of problems. The result was there was a long battle up to the Supreme Court about the question who is liable. And of course, the insurance represented by our firm stated, well, unless the people can prove which product caused the problem. There were many, many people producing. Some of the companies were bankrupt in the meantime, didn't exist, others did exist. And the Supreme Court said, no, alternative causality, you sort it out yourselves. So there was a basis for liability, and that, of course, at that time, every individual claimant was obliged to start individual litigation, prove damages, and so on. Of course, they wanted to find a solution for that, and that's the background of this act. But since it has basically only been used in securities litigation. What are the features? It is indeed a settlement agreement that is declared enforceable. That's basically the whole trick of the WCAM. And there are three parties: the party allegedly liable or immediately held liable, but there's no need for liability, only the willingness to settle something. And there should be a representative organization, a foundation that is an easily to be established, stichting in Dutch, easily to be established legal entity, which should have full legal capacity. And in its articles of association, which you draft up entirely yourselves, it should state that it represents the injured person, and then the third party is an administrator. Administrator is not having a place in the law, but it's an entity that basically is incorporated for the purpose of executing the settlement. And in the Netherlands, if it comes to those settlements, we happily go to the United States, where there is so much experience and organizations who easily can settle and have a long reputation in doing so. The key features are that indeed those representative organizations and the parties allegedly liable, they jointly request the Amsterdam Court of Appeal to declare the collective settlement binding for the entire group of injured persons. So it is all voluntarily. If there's no willingness, this act can be of no help to any of your Australian victims. And if the Amsterdam Court declares the collective settlement agreement binding, then it binds all persons covered by its terms, who are within the scope of those foundations set up, covered by a term, except for those who have opted out. And the binding declaration of the Dutch court is likely to be recognized, because you wonder, why should we go to the Netherlands, a very small jurisdiction, if it stops there? Well, what's the purpose? Indeed, but part of the European Union, this binding declaration is likely to be recognized in other member states of the European Union, plus the icing on the cake, Switzerland, Iceland, and Norway under the Lugano Convention. This system is, I would be tempted to say, unique in Europe, and makes the Netherlands an attractive jurisdiction for settling international mass damages, but always in conjunction with assistance, preferably in a jurisdiction where there are many more possibilities and reasons to create for a tortfeasor to ultimately offer a settlement. One remark about costs. In the Netherlands, indeed, the loser pays, but the loser pays only a fraction of the real costs. So I put a gloss on what you were stating. Indeed, there are jurisdictions like England where the loser pays it all, real cost. In the Netherlands, there is a very old, an old calculation model that the courts use. I think it was developed in 1838 and hardly moved up with the time. So in these type of cases, you could easily have 1 million, if not more, on costs, and ultimately the winner will be awarded 12,580 on the basis of a fictitious number of points. So that's the only remark, but for the rest, it was already explained. Quickly move to the settlement agreement. Again, this is just a settlement agreement, a voluntary agreement, and there should be mention made of compensation, an accurate description of the group of injured persons, let's say the class, the compensation that will be awarded, the conditions an injured person has to meet to be entitled to compensation, and how it can be obtained. So no brainer, just anyone who is able to do some legal drafting should be able to draft such settlement agreement. The requirements, legal requirements, are not very high. The interesting question is, of course, how do you become a representative organization? Well, that's first, you can found it. You put in the Articles of Association the description of the class, the group of people whose interest you wish to represent. It should have full legal capacity. That's checked for by the court. And the representative organization should, of course, by its statutes, by its Articles of Incorporation, also be representative of the non-Dutch persons. If you fail to insert that in your articles, then your representative organization cannot represent non-Dutch persons. In practice, indeed, this is an entity which is specially set up that can be done in a day with a civil law notary, and the persons who until now have incorporated are usually an established consumer organization or an investor organization. There's the VEB, the Association of Securities Owners. Basically, that's a kind of consumer organization protecting my small shareholders, and they have taken the lead and they have developed for themselves good business, and even part of their activities are funded out of the fees that they got when they got involved, for example, in one of the cases that was handled by a Dutch court in the Shell case. So the representative organization, to a certain extent, can state it is representative, and then the Dutch court will check. And how do they check it? There is some case law about it. They will first see, well, who are those organizations? Do they look representative? Is it properly described in the Articles of Association? And is anyone else raising his hand and saying, hey, those guys are not representative? And in the past, the court ordered and said, well, put some advertisements internationally and state what you're doing, and if nobody objects, then we assume that you are representative. So until now, the case law is very practically based, and you need to show, and if you are able to show that those consumer organizations are behind, or that you have a long-standing tradition to represent those interests, the recognition as a representative party should not be very difficult. The party allegedly liable, and that's the beauty of it, you don't have to admit any liability, you just say, I wish to settle for whatever good reason, can commit, and does commit itself by way of the settlement agreement, to pay compensation for the damage caused by the event or similar events. And any party wishing to pay could enter into such a voluntary settlement agreement. If you feel sorry for Shell, say, well, great company, how can it happen that they end up in this unfortunate case? I have the money, I'll pay the victims. I can say, well, on behalf of Shell, I will offer. And in theory, that would be possible. Any party wishing to compensate the damages can do, and in practice, of course, this is the insurance company or the party itself. And they also may form, if there are more parties, for example, in this famous desk case, they might form a special legal entity, an ad hoc vehicle, that makes the offer on behalf of all producers or all other parties involved. And again, the incorporation of such a legal vehicle is an easy thing and can be done. The administrator, the third party to the agreement, well, basically has to execute it, see to it that the payment is. Interestingly enough, the Act doesn't make any reference to the administrator was, well, considered not important, but in fact, of course, the administrator does, at the end, the real job. And we happily, as I stated, make use of established organizations in the United States who are able to do so. And it's quite a lot of paperwork, and it needs to be done in a correct way, of course. The procedure, standard procedure, first the settlement agreement, the representative organizations and the parties, they draft it, they sign it, and they request the Amsterdam court to declare that settlement binding. That's a petition. It's a very informal and easy, accessible procedure. Courts usually immediately arrange a preparatory meeting, which is not common in the Netherlands, but in view of the complexity and the potential number of people involved, they like to discuss how shall we further proceed, how can the settlement, how should the settlement be notified, what will happen during the hearing, how many people will pop up, what is the purpose. Then there is a hearing. Ultimately, of course, that leads to a decision, and there is a notification, and that is the start of an opt-out period, and ultimately there is the distribution. Nothing strange and nothing different from whatever class action at the end in the United States would have as a result. The main elements that the court considers are indeed, first, is this representative organization sufficiently representative? I gave you already some of the criteria developed in case law. Then indeed, is this collective settlement reasonable? And that's, of course, an uncertain factor. But of course, if the two parties feel that it is reasonable, the court should have very, very clear and solid reasons to declare that to be unreasonable. Basically, it's a protection against easy tricks where, well, let's say Shell would quickly enact a representative organization, make a quick deal, and try to get that enforced and therefore block all actions by any party who did not opt out. So deemed reasonable, and then of course the injured persons will have to be properly notified of the settlement. The court sees to that the binding declaration and this possibility to opt out, and payment has to be there. So it's not enough to say we are going to do it and then indeed not show the money. Money has to be in the bank. Only if money is in the bank, if there is sufficient security that payment can be made to all, will that settlement be declared enforceable. The opt-out, it was already mentioned, by result of this binding declaration, the injured parties will automatically become a party to the settlement agreement, except for those who have opted out. The court sets the opt-out period, and at least it should be 3 months from the moment of public announcement of the binding declaration. Anyone who opts out is not bound by the terms and thus retains the right to initiate individual proceedings against the parties allegedly liable. There are also examples of that in Holland, people opting out, starting proceedings, and the injured persons could not have become aware of their right to claim compensation during the opt-out period. Those people are able to opt out at a later moment once they are aware of the right. There's always some uncertainty, and parties in the settlement agreement may stipulate, and that's wisdom to do so, that the parties allegedly liable have the right to terminate the agreement if it lacks a substantial number of participants. Well, understandably, the whole purpose is to make life easy, to be able to finally settle matters and to avoid a lot of litigation. If this is not happening, then indeed there's an opportunity to go out. Well, the interesting question, of course, was, should the Dutch courts accept jurisdiction also when basically the case has no link whatsoever with the Netherlands? And the answer is yes, they do. Main grounds, of course, for normal jurisdiction are general jurisdiction, the defendant is domiciled in the Netherlands, a special jurisdiction relating to a contract, if the place of performance in question lies in the Netherlands, to tort, place where the harmful event occurred or may occur lies in the Netherlands. In the event of a number of defendants in Holland, only one is sufficient to bring in all the others, and the potential claims, provided that the potential claims are so closely connected that it's expedient to hear and determine them together to avoid the risk of conflict in judgment. All that is wisdom from the Brussels Convention. And then indeed there can be prorogation of jurisdiction, a choice of forum, or indeed the defendant enters an appearance without contesting jurisdiction. So already many possibilities are there. You only need to view injured parties in the Netherlands, and then on the basis of the existing jurisdiction, we could bring them in. But, of course, if two parties wish to submit the claim, that is voluntary jurisdiction, and that is accepted by the court, and they did so. What does this judgment bring us? Well, this is Europe, part of it, and the dark blue and the green, that is the European Convention and the Lugano countries. So in all of those countries, in principle, this judgment of the Dutch court should easily be enforced, provided there are no formal mistakes, but the criteria to attack such a judgment are very, very limited. And main grounds for jurisdiction with respect to proceedings instituted by a petition, if a petitioner has his domicile in the Netherlands, that's of course if you found that foundation, the representative organization in the Netherlands, that's already met. It can be related to writ of summons proceedings that are pending in the Netherlands or otherwise sufficiently connected. So plenty of possibilities. Last but not least, I'm not going because it's more interesting to have some discussion in the time left, but the present case that is still under, on its way is the so-called Convivium case. We are now at the level of filing the payment notes. It's an enormous job. The paperwork is big, but that's going on. It was an F-cube case. Shareholders of Convivium, a Swiss reinsurance company, claimed damages for the loss of value of the share price after Convivium announced increases to its loss reserves in the period 2002 through 2004. Praise the Lord, they started to litigate in the United States, and indeed the US court offered an opportunity, but not for the non-US persons. The non-US persons who had purchased Convivium securities on any non-US stock exchange were expressly excluded from the class. The case then was settled in the United States, and the settlement agreement was approved by the US court. That, of course, did not offer any remedy to the non-US persons who had purchased those securities, but they decided to terminate things, to start such a collective mass settlement procedure in the Netherlands, and they requested the binding declaration of the settlement agreement, and the Amsterdam Court of Appeal assumed jurisdiction to hear the case, while there was no or only a very, very weak link. The bulk of those shareholders was Swiss, was anyway not Dutch. I think there were only a very, very, very few. They had different grounds for jurisdiction. And indeed, as two of the four petitioners were domiciled in the Netherlands, those foundations set up, and the case was also closely connected with the jurisdiction. That's why the Dutch court accepted jurisdiction. Once you have the judgment, indeed, you can have that declared enforceable in all other European countries and in those countries with which, in absence of a treaty, there is a treaty for the mutual recognition and enforcement of judgments. The Netherlands do have a number of those treaties, not with the United States, but in Holland, in principle, a US judgment can easily be recognized and enforced, provided that there are no strange animals, so no punitive damages, no sky high, no jury trial. Those are elements that Dutch courts might say, well, that's contrary to our public policy, so we don't do it. But any normal case litigated in the United States and good motivation, no formalities, will easily be acknowledged without having to retry the case. And I was informed that basically the same treatment is given to Dutch judgments in the United States. So although there is no treaty, in principle, it is, both countries will acknowledge normal, so to say, judgments rendered. Some recent developments, because also this collective settlement claim may take time. Again, we did not have any mass claims. We had a possibility, but only to obtain declaratory judgments in collective action. So that was basically the legal question would be decided first. And once that was decided in favor of the victims, then indeed everybody could file individual claims. That was, of course, still cumbersome. This act tries to offer an opportunity, provided there are two willing parties. There's now an introduction of a possibility to request a preliminary ruling from the Supreme Court on any legal issue, and there are some other amendments to this act making it even more attractive. Has it been used until now? Yes. Has it been used very much? No. It's not, maybe in comparison to Japan, a number of cases, 40, I don't know how many Japanese there are, but indeed, for a small country in the Netherlands, since its existence, since 2005, there was this famous test case, that's where it started, personal injury, and then Dexia, a very unlucky bank, sold misleading products, and litigation was started, well, hundreds of thousands of individual cases, so courts were overwhelmed and needed to have extra personnel just to process the claims, and they tried to find a way, how can we do it? So happily this case, it came in, and Dexia was not eager to settle, so they first brought all those cases up to the Supreme Court, the various differences, the various different products. Has taken a long time, but ultimately that's where the case was applied. Shell, having been beaten into submission in the United States, waved the white flag and settled the non-US investors in the Netherlands. Vedior was a Dutch company, Vidar, an insurance company that went broke, and then finally Convivium. So, where did we see it? So, summa summarum, there is an opportunity for your Australian victims, but only once there is a willingness to settle. And as we all know, that willingness usually is not there without this enormous stick, and the Dutch carrot being that if they settle, it might at least avoid also additional litigation in all of those European countries. Well, may seem attractive once the decision and the mind has been made up, we'll settle. If not, no competition for any US litigators. On the contrary, I think a close cooperation will bring the pleasure. In the US, the big money, we don't have that in Holland, but maybe the next act can take into consideration the learnings I did today. Thanks a lot.
We do have time for questions. Since we didn't put anybody on the panel, we'll just go within the sort of circle. I'll go. Sorry, good.
I just wanted a really quick question about the Shell case. And there's Shell and there's Shell and there's Shell. So is this? So yeah, is this the 2010 decision by the lower Dutch trial court that Shell, that they accepted jurisdiction in this really F-cubed case where there was the allegation of pollution in the Niger Delta? Is that the case that settled?
No, this is not the Niger Delta. No. No, the Niger Delta is still, it's still offer, and Shell just a couple of weeks ago had some victories. 4 of the cases were kicked out for lack of jurisdiction, and a very minor part of the case that was awarded. So no, this was just mistake. Yeah, this is the reserve case. They understated, seriously understated their reserves, and that oil reserves, which of course is the driving force behind the stock price. And when it was discovered, well, they cleaned up the top, and the shareholders started to sue in the United States. And once that was settled, then indeed Shell wanted to settle also with the Dutch. And that's where it was the first big case where this small shareholders association made some good money, because they negotiated, and it was the question whether that was ethical or not. In the United States, you would say rightfully so, but they negotiated a donation to their fund of $1 million. And people in Holland were saying, wow, is that allowed? Well, it was, yes.
Okay. I'd like to take your seat. I'm going to take moderator's prerogative to, since Winfried introduced one of the subjects of my question, the concern about the Netherlands procedure, as I understand it, or one of the concerns, involves the ethics of class action settlements and some of the abuses thereof, including some parties to the proceeding getting more money than might be otherwise entitled to by their share of the damages, as well as attorneys getting a lot of the money. And the Shell case being a possible example of that, you pointed out this foundation whose main role in this whole thing was simply to serve to provide you know, they needed a foundation before the court, gets a lot of money for this service, which raises ethics questions in terms of U.S. class actions. And I kind of rolled my eyes because you talked about the fact loser pays being very small. Nevertheless, a big part of the Shell settlement were the attorney's fees, both for the original U.S. attorneys involved in this action and for attorneys, I think they were still U.S. class action attorneys, but who had simply represented the parties in this proceeding. And so a lot of the money, as I understand it, the settlement went to attorneys and a party was brought in there. And of course, that's kind of a concern about class action settlements. And now we have this court that's looking at this whole thing completely independent of the merits of a prepackaged deal. Comments on the ethics of the whole thing?
As I mentioned, the Dutch court will have to review whether the compensation offered is reasonable. And this will be typically something that a court would look at. What remains finally for the injured party. And to my knowledge, quite often in the United States, the whole case has cost hundreds of millions, if not more. And then ultimately, the shareholder can pick up somewhere 0.25 cents per share. And well, it's basically hardly the standard costs if you are a small shareholder. And that's where the court has an opportunity. And in the Netherlands, there is indeed no contingency. The fees will definitely not even end up in percentages of what you would see in a big contingency fee case. And there is well, Europeans don't like it. It's also not so necessary. I always tell people when they say, oh, they're in the United States, all those contingency fees. Well, basically, thanks to the system, a lot of wrongs are repaired. And in Holland, there are less wrongs because people are insured or will become unemployed, but have the state allowance, and so on and so on. So you should see it in the full context. But that's where the courts have an opportunity and definitely will look at it.
Okay.
So I have a related question for Winfried. This is a fascinating mechanism, and I can understand how it works within the European Union because of the Brussels regulation and the Lugano Convention. It seems to me that if I were representing a defendant corporation with respect to non-European shareholders, either in the United States or in Australia or somewhere else, the effectiveness and so my willingness to settle would depend very much on whether I thought that this settlement would be binding on those Australian shareholders, for example, and so would preclude the action against me that might be brought in Australian court, because I'm not going to be willing to do it if it's not going to preclude that. That's going to depend very much on the rules of res judicata with respect to in Australia, because these would presumably be parties who had not opted in are parties, and it's the same claim. In the United States, of course, that would vary from state to state because these are rules of state law, so it gets very complicated. And I think the critical question, yes, you're right, in general, Dutch judgments would be enforced in the United States, but the more particular question, which I really don't know the answer to, and maybe someone in the room does, is how about class actions? And I think the critical question is that a U.S. court would focus on is what kind of notice did the parties have, and was it sufficient? The potential plaintiffs who didn't opt out, who are now potentially bound, yes, technically they're considered parties, but would a U.S. court or Australian court or whoever's asked to give res judicata effect to the settlement consider that they had enough notice that they should properly be bound and forfeited these other rights? And I think that's a fascinating question. I don't know if you have any comments on it or anyone else in the room.
There is no practical experience yet. The cases, as I mentioned until now, those 6 were basically all driven except for the typical domestic Dutch cases where there were none or hardly any DS claims. There were not many non-Dutch victims. But the other cases were driven in the United States, and once the settlement here was reached or declared enforceable, then indeed they wanted to extend that to the others. But I agree, it's a total different, and there is no litigation, it's a settlement, and of course everything will then boil down to the question, is this organization sufficiently representative?
But it doesn't get the corporation off the hook unless it's recognized elsewhere.
Exactly.
And that's going to depend on some questions of local law in the absence of a treaty.
Yeah, absolutely. And well, such a major jurisdiction like the United States.
I'm going to
also at Grant Eisenhower, which was the U.S. firm. The story within the story on Royal Ahold is that a firm called Bernstein Liebherr had the U.S. case and had such an antagonistic relationship with counsel for the defendants that Royal Ahold approached our firm and asked if they could settle. And so this mechanism was created, and a good year and a half of work went into creating this stichting before Morrison came down. And so when we're talking about fees and all of that, you have to understand the risk that G&E was undertaking at the time that they were doing to establish that foundation. The question as to whether or not after Morrison these things will be binding is very much the issue. And also there's an issue that hasn't quite squarely been addressed today. Convivium touches on it, which is I represent U.S. institutional shareholders in BP, in RBS. These are massive frauds, just like Vivendi and Parmalat before them, where U.S. courts have said you cannot recover for your shares purchased abroad. So in BP, there's a class action in Canada purporting to assert claims for purchases on the Frankfurt and London exchanges. It's unclear if the Canadian court, that case was originally filed in Alberta, now transferred to Ontario. It's unclear what the courts will do, even in the wake of IMAX, to say we will extend to assert jurisdiction where the U.S. would not. So then the issue is, do we file in the UK? The Jackson reforms that are coming in the UK in April of this year will bring derivative-style actions that will allow for certain kinds of claims to be made. Section 90 of the UK's Act is very much like Section 11 here, or with a strict liability standard. But what I'm saying is there's going to be, as I would see it, an explosion of litigation abroad that would then challenge the ability to argue under a stichting that there is res judicata, because you're going to say these are different claims. How could I be foreclosed for my strict liability claim in the UK when somebody else had a different kind of claim in France? And there is litigation in Japan. There's Olympus and Toyota. It's happening everywhere, and it's a true problem. So the Supreme Court, I see, has caused two unintended or intended consequences. I don't know. There's going to be litigation all around the world that is going to be some kind of mass form. People will be trying to, and people, in fact, plaintiffs' bar is trying to be strategic about what's the next issue that we test in the Netherlands. Is it, can we cover for U.S. investors? What is the nexus, the Dutch nexus that we have to have? And the second issue, quite simply, is foreign companies are not going to list on U.S. exchanges. And that's a deeper economic problem. It's not a legal issue. But the question is, how do I recover? My pension funds in Ohio, in Wisconsin, have not stopped trading on foreign exchanges. It's just, how do we recover for them, if at all, or is it just a riskier investment? And what does that mean for our pensioners here in the United States?
Ken. Yeah, I wanted to, I think, follow up on your question, though I'm not an expert in the area. One of the things that you did not talk about was choice of substantive law. So I take it that the issue of whose substantive law is being applied is completely internal to the negotiation. And, okay, and that gives rise to your question about what claims are being compromised. And I also, again, as someone who's outside of this area of law, I take it because this is a non-compulsory procedure and it winds up with a court judgment. For both those reasons, it can't qualify as an arbitration under the New York Convention. And so you don't, in New York Convention states, there's no effect, right?
It is not, no, it's not equal to an arbitral award.
Okay.
Here.
Okay.
Dick.
First, going back to the point that Bill Dodd raised, this problem of whether there is adequate notice in a foreign country, right, to provide for closure, came up, of course, in a very different context in the Holocaust era forced labor settlement, right? And there, of course, the firms did not want to contribute to the pot unless there was legal peace. And legal peace involved the question whether U.S. courts notice campaign. In other words, the courts, it was Judge Scheinel in the New York Southern District, looked pretty carefully at the degree of notice, right, and then decided that this had been adequate for foreclosure of cases here. In other words, this whole opt-out problem was in the sense of that. And I would think as this proceeds, that's going to have to be the tack taken. There will be a little bit of a risk, right? But if you can get a judgment from a U.S. court that the notice was adequate, that I think would do the job. I did have a different question for you, but that is, I don't quite understand the issue. The court is making a settlement. Are there fact findings in that settlement that could bind in the sense of preclusion or res judicata in other actions? I don't think so.
No, basically the court, well, it's not rubber stamping, but close to it. Two parties, they negotiate a settlement, and that settlement is shown to the court. The court it does some investigation. Is there fair compensation? This is not a Mickey Mouse settlement, but does it have an appearance of a true reasonable settlement? Secondly, who are those parties? Are they representative? And then, of course, the court sees to it that the money is in the bank and supervises the mechanism of advertisements, where, how, what to do. But indeed, there is no material, and that's also why there is, in most of those cases, there is no admission of liability. But it is just a voluntary settlement, whereby, that's why I refer to the allegedly liable. That's in the open.
But my reason there was to ask, then what is the context in which the issue of the Brussels regulation or the Lugano Convention recognition in other jurisdictions bears on this? I mean, this settlement is self-contained. Right?
Yes, the question, of course, what does the court add is that indeed it is declared binding for everybody who is allegedly represented by the representative organization.
So it bears really
and that decision, let's say blocking, unless you opt out a party from starting again, that is to be expected. But again, there's no case yet how it survived. It's expected that will survive.
So that is really circling back then to Bill's question. That is to say, what is the effect elsewhere? It's the opt-out issue is what the other jurisdictions.
That's basically the only added value of the court.
I want to do one thing. I had a couple of questions I wanted to pose to Mark, so I'll use some moderate prerogative here. One of which you alluded to, which was the ability of non-Canadian parties to bring actions in Canada. But the other one, which also may be broader, Winfried and other countries might address, and that is in a loser pays system in a collective action. Does that loser include every member of the class? And if so, does that create a strong pressure not to opt into the class and otherwise make the whole thing impractical? And so those are the two questions I wanted to put on the floor. First, in terms of the ability of non-Canadians to go into the Canadian system, and second, who pays in a collective action on if the class is unsuccessful and loses?
Well, I'm not an expert on Ontario law, but what strikes me is that under the IMAX and Canadian solar decisions, the company, with respect to Ontario, must be incorporating in Canada or doing substantial business in Ontario in order for the court to have jurisdiction over the claim. With respect to, I should add, if I didn't before, that its securities are traded on an exchange in Ontario. Then with Canadian Solar, its securities were traded on the NASDAQ, but not on the Toronto Exchange. The defendants made the